Good evening.
Can the leader of the meeting mute everyone?
Housing Association. Thank you so much for coming here today and joining us on this beautiful spring Manitoba morning-ish. We have got Darren Cooper here today from the Residential Tenancy Branch updating us on the Lease Act. And we've had so much joy and enthusiasm for joining this meeting. So thank you so much, everybody here in person and those online as well. We are recording at times too. So if you're not in person, you'll get to watch it later on. The intention of this is to make sure everybody involved in life leases is up to date on what the so Darren Cooper is the manager of rent eviction and life leases, the Residential Tenancy Branch. And I will pass it over to him now. Thank you so much. Oh, also one more. Please save questions till the end of the presentation. We'll definitely be behind that time and we're hoping that some of the questions will be answered as well. So, okay, you're up. Thank you.
Can everybody hear me? Is this on?
No.
Yep. No?
Yep.
Oh, okay. Can everybody in Zoom land hear me at least?
Yep.
This computer. This.
I'm not sure if you can hear me or not.
I can hear you, Darren. I'm on Zoom.
The sound is good, Dawn, with you.
Can everyone online hear me?
Yes.
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 Audio is fine.
I think you might have
Yes.
your mute on, so I can't hear your response.
Yes, I can hear you,
Yes, we can hear you.
Oh, okay.
but everybody else needs to be muted if you're going to
It's
talk.
okay, I'll just stay here. And
The mute.
okay. Just so I can kind of maneuver through this PowerPoint.
That's me there.
Thanks for having me. I'm the in-house life lease expert. I use that term lightly for the branch. And I know that today it was entitled Changes to the Life Lease Act, which I will touch on. There have been some recent changes in May and more coming. But I thought what I'd begin with is to just sort of go through what the Life Lease Act is all about in terms of landlord and tenant rights and obligations, and how the Residential Tenancies Act ties into that for life leases. A lot of tenants and board members and even property management companies sometimes aren't aware that the act applies to life leases almost exactly the same way it would month or fixed term 12-month leases when it comes to certain things like mediation, adjudication, repair issues and whatnot. So touch on that just so you understand how the branch can get involved if you have a dispute with your landlord or the board as a tenant or vice versa. So in December 1999, the Life Lease Act was created. And the reason why it was created is the Residential Tenancies Act did not provide any sort of avenue of decision-making or information on tenant landlord rights when it came to Life Lease Act. So the main reasons why it was created was to ensure landlords give tenants certain information before the tenant moves in. That they live up to their obligation when it comes to providing financial updates, having annual meetings and things like that, which is unique to non-for-profit life lease complexes. To ensure a landlord establishes a refund fund, what we call non-assignable leases, so everyone understands what that is if I want to refer to it. Majority of non-for-profit life leases in Manitoba are what we call non-assignable. And what that means is when the tenant moves out, the landlord refunds their entrance fee or a portion thereof, and then finds another tenant to move in and pay a new entrance fee. There are some assignable leases out there, which is where the tenant, when they decide to move, it's their responsibility to find someone to pay the entrance fee to them. So there's positives and negatives. Positives of non-assignable is it doesn't matter how the market is doing. You should get usually up to 95% of your entrance fee back. The negative, some tenants have said, is that as the cost of moving to your next stage in life is very high, the entrance fee you get back, or 95% or whatever it may be, is not even a drop in the bucket to what you need to move on to the next stage of your life due to inflation and everything else. So the preference for those types of tenants would be, I'll take my chances with the market and I'll put it up for sale and see what I can get, and hopefully get much more than what I paid 20 years ago for my entrance fee.
So just, from my understanding, we call those peace of minds. So when they're getting back to the landlord, are they resold, at a higher price then, or the same? They ever increase,
Most landlords are hesitant because this is all about affordable housing for seniors. That's why life leases were invented. But some landlords, the Life Lease Act does not prevent them from doing that. And some landlords will do that as a way to increase their reserves without having to increase the rent for the existing tenants too much. So legally, they can do that. And some, they're reluctant in my experience, but some find they have no choice. It's either increase the rent significantly or find other ways. Historically, landlords were very, a knee-jerk reaction to unexpected expenses was to refinance, get a second mortgage. But they're finding now over the years that is not doing anybody any good. So the other options you have is increase the rent for existing tenants and or increase the entrance fees significantly for new tenants that are moving in.
And if you could save the further questions till the end. It just helps and not like.
So another unique characteristic of life leases for nonprofit is there has to be a reserve fund. Currently, the legislation doesn't mandate a minimum. That's one of the changes we've been considering. And I'll get into some of the changes that have been made in May of last year. Unfortunately, I'm not at liberty to talk about the ones that haven't been mandated yet, that I'm working on personally. But I can maybe give you an idea of some of the suggestions that were given by a focus group that I met with for 2 years, actually. That was composed of board members, tenant reps, property managers. We had a lawyer that specialized in life leases there as well. So I'll touch on that later, and the Life Lease Act is also meant to tie life leases to the Residential Tenancies Act, to make it clear how that act applies to life lease tenants. So as I said, the Life Lease Act came into effect in December of 1999. There were already obviously some life lease complexes that existed before that. So in the Life Lease Act, there's a section 6 to be exact, that excludes what we call existing or pre-1999 life lease buildings from certain parts of the Life Lease Act. And the reason for that was not to create undue hardship on those buildings. Ones that came into effect, first occupancy was after December 1999. We refer to those as the new life leases, and the entire Life Lease Act and the regulations apply to those buildings. And an extra is, I'm not sure if any of you, actually I meant to ask, how many people here are actually tenants? Oh, not everybody. Board members, anything? Tenant reps, if you're on the board, okay. All right. So you may have been involved or with the tenant's request for what we call tenant extras. This is unique to life leases as well. Where before moving in, the tenant wants some upgrades done and is willing to pay extra for them. 99% of the agreements I've seen, those tenant extras are not refundable. They stay, tenant enjoys them while they're there. When they move out, they stay with them. I have only seen one complex that would refund the tenants when they moved out. Very rare. So I touched on entrance fees and refund funds. For an existing, again, pre-1999, a landlord's not required to have a refund fund. And the entrance fee, believe it or not, may or may not be refundable. For a new life lease, post-1999, a landlord must have a refund fund. Currently, there's no minimum, however. And if it's a nonprofit life lease, the landlord must refund at least 95% of that entrance fee when the tenant moves out. Again, for a non-assignable. Some tenants, I did have some questions came in. One of them was, when is the landlord expected to pay back my entrance fee after I move out? If it's a post-99 new life lease, the tenant must be paid back their entrance fee after what we call the tenant's priority date. As soon as the funds are available. What that priority date is, the date tenancy ended, or the last day of the third month that the tenant gave notice to moving out, whichever is later. So a tenant may have given 3 months notice to move out. 5 months from now, it would be the 5 months. For existing entrance fees, however, it really comes down to what the life lease agreement is. So I have a gentleman I've been dealing with for 4 years in a rural area, pre-1999 building. He's been waiting for his entrance fee for 4 years. And the reason being is the life lease agreement states that you will get your entrance fee back when we find someone else to move in and pay a new entrance fee. But there's just no interest in that area. So he's been waiting for a long time, and unfortunately, the legislation, the way it sits, is not of any help. So
Can I just ask a
some
question
landlords
about
have
that?
tended to, when you move out, you want your entrance fee back, deduct it for unpaid rent, damages, cleaning costs. Under the current legislation, the landlord cannot do that. Unless the tenant agrees, yeah, take a couple thousand off. Or the landlord has filed a claim against the tenant for whatever it may be, unpaid rent, damages. And they've received an order from our branch awarding them some compensation. If they still have the entrance fee, they can then deduct it based on that order that they received. Unfortunately for landlords, usually the tenant's been refunded the money and it's long gone before we get a chance to hold a hearing and issue an order. So then they have to chase after the tenant, or maybe their family of some sort. But I haven't really seen, to be honest with you, a lot of claims against life lease tenants. So I did talk about an assignment. So it is permitted where the tenant goes out and finds somebody to take over the unit at whatever amount they can negotiate. It's permitted if the lease says it is. And the lease states at least 95% of it is refundable. Whoops. This is one bone of contention with some tenants or tenant reps, more like, with the annual reporting. Landlords have often told me they find it a challenge to follow the act when it comes to annual meetings. They must call a meeting no later than 6 months after the end of the fiscal year. And they must give the tenants at least 30 days notice, not more than 50 days before the meeting. Some landlords claim that their accountants or trustees, whoever it may be, drag their feet, can't get the meeting until 7th or 8 months. So we have to remind them of their obligation under the Life Lease Act. In addition to the notice they have to give the tenant of the meeting, they have to give 3 schedules should be our prescribed form that we provide, but there are some versions out there, which is okay as long as it covers everything it's supposed to. There's the refund fund summary, the reserve fund summary, and then the previous fiscal year and the current upcoming fiscal year's expenses that there's budgeting for. Tenant representation board meetings, usually it's 2 tenants. Landlords must give the representatives notice of the board meetings along with a copy of the bylaws. They have the right to speak, but not necessarily the right to vote. Some life leases out there give tenant reps the right to vote, not a lot of them though. And representatives are entitled to receive the same minutes the board members do, excluding any personal information. What that means is if the board talked about caretaker salary or a problem tenant of some sort, that gets what we call extracted out of the minutes that the tenant reps get. There's personal information about another tenant that they don't want to share with all the tenants. It's a breach of that tenant's privacy.
May I ask a quick question?
Currently, if the majority of tenants request audited statements for a nonprofit life lease, landlords must oblige, and all the tenants are entitled to get a copy of that. I'll just throw it in there that one of the amendments that was made in May was that financial statements now have to follow generally accepted accounting principles. There is a life lease regulation that goes hand in hand with the Life Lease Act. And it lays out trustee requirements, what must their qualifications be, insurance, what kind of insurance do you have to have in terms of liability, and mortgage terms as well. There's also what we call an investment restrictions regulation, and that's landlord is limited to what they can invest the refund fund, or sorry, reserve fund in order to protect it, so that it's not lost by some risky investment. There's certain limitations as to what kind of financial institutions you can invest those funds into. Now, the existing for 1999, they're excluded from that or the previous entrance fees. But any new entrance fees they get for new tenants, they have to abide by this regulation. Now, there's not many for-profit life leases out there, but the ones that are, or that do exist, sorry, they have to abide by the guidelines. So this year it's 3%. If they want to go above, a little separate application process they have to do through the branch, and then we make a decision what they can justify. But for nonprofit, the rent is not regulated by the guideline. However, tenants can, within 30 days of getting notice of an increase based on the budget allowance proposing, ask us to do a life lease review. I do about 10 of those a year. And we just look at to see if the expenses based on the history of the building that they're budgeting for seem reasonable, that they're directly related to the operation of that complex and not to something else, that the rents are being calculated in accordance with the life lease agreements, i.e. the tenant's proportionate share, things like that. Then what we'll do is issue an order setting the rent for each tenant, and the tenant and or landlord has the opportunity to appeal our decision. And if they do, it goes to the Residential Tenancies Commission. They hold an actual hearing. They have a panel of 3 that hear it, and then they make a final and binding decision. If for a nonprofit landlord has a budget, charges rent accordingly, and they come up short, they're under budgeted, tenants are responsible to pay that shortfall usually. There are some life lease agreements out there that say, no, you're not responsible, take it out of the entrance, which usually translates into an increase in rent next year anyways. But If there's a surplus, again, depending on the life lease agreement, the surplus goes back to the tenant or it goes into the reserve fund. So these are the changes up to date. Like I said, we worked closely with various stakeholders in making amendments to the Life Lease Association. The biggest contributor, but not the only one, was the Manitoba Life Lease Occupants Association, which mostly were tenant reps on boards that came out. We spent several months, as you know, working on it, had a change of government, so it got shelved, came back and restarted everything. I got this through in May, the changes I'm gonna walk you through. And then the NDP took over, and it's gonna take a while to start the wheels rolling, but it is in the works. So I believe actually, maybe this week, the deputy minister of my department is meeting with the MLOA just to discuss where we're at. So in 2023, we had 3 changes. One was, and a lot of people aren't aware of this, prior to this first one, if a life lease complex went into foreclosure, bankruptcy, and someone took it over via a mortgage sale or a tax sale, that landlord had the right to terminate all the life lease agreements. The tenants would have the option to go into what I call a regular tenancy, like a 12-month renewable. But the biggest kicker was that new owner is off the hook to refund any of the entrance fees, which in my mind was unbelievable. I wouldn't know ever came up with that back in the day. So that's been eliminated. The landlord can still terminate and keep you on as like a 12-month lease renewable tenant, but you got to get your entrance fees back. So the next one was that currently, or prior to this, there was no requirement for a complex to conduct a reserve fund study. And a lot of boards were reluctant because of the cost. So the building was going unassessed for several years, and then all of a sudden all these problems start occurring and your reserve funds are significantly lower than what they needed to be. So now the Life Lease Act's been changed that there's a requirement to do regular reserve fund studies. It hasn't been what we call proclaimed, put into force, because this requires, and the next one as well, changes to the residential rent regulation, which is, we're basically ready to introduce that, but the earliest we can do it is the summer reading at the legislative summit. Once those regs are in place, this becomes enforceable as part of the act. And the other one I touched on is audited financial statements or have to be done in accordance with generally accepted accounting principles. As I said, we've completed the draft amendments to the regulation, and we've got to get those in before the act will come into force, not regular. And again, as I said, we're just continuing to move on. We've got several recommendations that I'm going through and seeing what we can and cannot do at this point. Well, hoping to have a few more on the table this year. Probably more likely in the fall than summer. So I just wanted to touch a little bit on the Residential Tenancies Act. It's always shocked me, or for lack of a better term, that tenants and landlords alike don't realize the rights and obligations under the Residential Tenancies Act. Some of the ones I've seen over the years is landlords charging unauthorized fees to tenants, like to be on a waiting list or to use their realtor. Seen that. The only fee a landlord can charge a tenant outside of an entrance fee or a life lease is security deposit, also known as damage deposit, which is half a month's rent. Pet deposit if they allow pets, which is a full month's rent. And then if your building has what we call tenant services, so like meals and cleaning and all that sort of laundry. The first month of that fee you can charge as a deposit as well. That's it. So we've seen a lot of additional fees being charged that we had to order landlords to pay back. Same with assignment fees. I've seen assignment fees for life leases that were up to $500. The maximum under the act is only $75. That's it. So if you want to assign your lease because you're moving out, the landlord is going to incur some expenses, you know, paperwork, whatever it may be. Most they can charge you is $75. Repairs and maintenance. I've seen many life lease agreements that say the tenant is responsible for any and all repairs and maintenance. But under the Residential Tenancies Act, that's not the case if it's due to normal wear and tear. If your appliance breaks down, it's not due to your use. Landlord has to replace it at their cost. If your flooring starts coming up, again, not due to your abuse, they have to come fix or replace it. We actually have a whole unit in our branch called the Investigations Unit that deals strictly with repairs. We have 4 officers that if you, as a tenant, fill out a tenant request for repairs, we'll go out, we'll inspect, we'll determine what needs to be done, give the landlord a certain amount of time to do it. If they don't, we have the authority to issue an order, not only ordering them to do the repairs, but if they don't, ordering the tenant to pay the rent to us. And technically, we can order almost half of the tenants in the building, pay their rent to us to get that repair done. So, got ahead of myself, but these are the, tenant service deposits are only half a month of that charge. Well, these are just touching on some of the obligations landlords have during a tenancy. Doesn't matter what kind of tenancy it is. You know, make sure doors and locks are reasonably secure, not to, some landlords who can't get behind their rent, they can't track them down to change locks. Figure that'll get their attention, right? I've seen some landlords that take the whole door off the unit. An obligation to make the unit available the date the tenancy begins. To provide rent receipts, not to withhold any services. So this is usually in the case if the tenant's responsible to pay utility and they fall behind. And then the utility company hires or contacts the landlord. Sometimes they'll shut it off. They'll tell the utility company to shut it off. Can't interfere with the enjoyment of the rent unit. Have a duty to investigate complaints, whether it be the contractor, landlord's hired, one of their property managers, or even another tenant. They have a duty as a landlord to look into it. They want to enter your unit for some reason. A, they have to have a reason. B, they have to give you 24 hours written notice. Usually, if a landlord starts inspecting a tenant's unit more than 2 times a year, you have to look into it because there might be a harassment. Tenant has the right, however, if they're given notice, to give an alternate entry time, if that doesn't work. Obviously, if it's an emergency, if a landlord thinks there's a burst pipe, or flood or fire, and they don't have to give notice. Landlord doesn't have to be there. They can have a tenant, or sorry, a landlord rep come in, like a contractor, caretaker, whoever it may be. And the tenant doesn't have to be there. So saying, well, I work every day, I don't want you in here while I'm working, or I'm gone for 2 months to Florida, or whatever it may be. That's not a reasonable excuse not to let the landlord. You don't have to be there as a tenant. I know as a tenant it's more comfortable, but and if tenants refuse entry, landlords can give a warning, and then can actually terminate the tenancy because you're interfering with the landlord's obligation under the act. As for tenant, obviously, you do pay rent on time, not to interfere with the locks without the landlord's permission. keep the unit clean, don't alter or redecorate without landlord's consent. Don't disturb others, don't impair safety, don't interfere with the rights of the landlord. Do not engage in unlawful activity. So some of the services we provide, which includes like police complexes or repairs, as I say, we can get involved. If there's a dispute between a landlord and tenant, we have mediation. And sometimes we'll mediate a payment schedule if the tenant got behind in their rent. And sometimes we'll mediate a move out date that both the landlord and tenant can agree with. Push comes to shove, if mediation doesn't work, landlords and tenants can file for a hearing. The landlord can file for an order of possession, that's for, they want their unit back. It's because the tenant's been breaching some sort of obligation while behind the rent, damage that they won't fix, nuisance and disturbance. Both landlords and tenants can make claims for compensation. And landlords and tenants can ask for a determination hearing. They're not sure, the landlord says, I'll give you an example. Quite often when we have tenants that live in a hotel and that's their permanent residence, their mail goes there, they pay the deposit. And then there's a problem and they come to us and contact the owner says, you guys don't have jurisdiction, we're not tenancy, we're a hotel, we're a commercial business. So we have to make a determination, do we have jurisdiction in this case? Because we do in some hotels, depending on the tenancy arrangement they have with the tenant. Already talked about rent reviews that a tenant of a non-for-profit can request. So some of the difference, notable between the Residential Tenancies Act and the Life Lease Act is there is no prescribed form for a tenancy agreement. Other tenancies, you have to have a certain type of agreement. Actually, you may have heard that Prime Minister Trudeau recently proposed a bill for tenants, and one of them would be to have a prescribed tenancy agreement that is nationwide, same one for every province, every city. But life leases that wouldn't apply to. Pre-lease payments are only for new buildings for life leases. And that's where you put usually, I think the max right now is 1,000 on a new development, just as a, I'm serious about this sort of thing. And then if you get in, it'll either be refunded to you or put towards your entrance. But those are only for new builds for the first tenant moving in. That's just, if you do terminate as life lease tenant, the act requires you to give 3 months notice. Now, there's some limitations for landlords when it comes to life leases if they want to terminate the life lease. For example, with other types of leases, if I want to sell it and I've found a prospective buyer and we're in the middle of signing contracts and everything, I can give you notices on behalf of the purchaser to move out. And it depends on the vacancy rate in any given city, how many months after. And whether you have a fixed term lease that we have to wait for it to expire. Can't do that for life leases. If I buy it, I become your landlord. And if they want to terminate for demolition, renovation, or conversion to like a commercial space, they can do that without applying for month-to-month or 12-month leases. Tenants can still dispute it and ask that a hearing be held. But they have to, if life leases apply to the branch for our permission, even give that notice, let alone have you move out. So just in conclusion, life leases fall under both acts. Well, the Life Lease Act outlines landlords' obligations for specific things for life leases. Residential Tenancies Act fills in the blanks for other obligations and rights of tenants and landlords. And yeah, just rent increases, nonprofit, not bound by the guideline, but you can request a review. For-profit bound by the guideline have to apply for above guideline rent. That's it. I don't know.
Start off with a couple of questions.
Yep.
First of all, A couple of slides back, I was speaking about landlord's rights. I took it to suites and those kind of practices. I think there might be some confusion sometimes because the landlord, with respect to these buildings, is the board of directors. These will be services that actually oversee those buildings. All of those tasks that we referenced there are generally delegated to a management company who actually so the delegation of that work to the management company still all tied into the responsibility of the land.
Yeah. Under the Residential Tenancies Act, property management companies are considered the landlord. You'll often see where if on behalf of the board, the owners, or any type of tenancy, a property management company gets involved with the branch, they'll put their name on whatever form they fill out as the landlord. And caretakers or contractors are also, they're not considered the landlord, but agents thereof, so they have the right to come in on proper notice as well.
One of the slides.
If you don't mind, people might want to get it as well, so you could move closer to Darren.
Oh.
Yeah. Thank you. No, it doesn't make it's just.
Okay.
One of the slides indicated that it was the landlord who selects the tenant representatives or to go on the board. But section 18.11 specifically says the tenants of a nonprofit landlord may select their tenant reps. So
Yeah.
that might be misleading, that's all.
Yeah, that's why I probably have to change it then. It was meant more like the landlord can determine how many.
Yes, well, that says it, but it's the tenants that actually select the tenant
Yeah.
representatives.
Yeah.
Okay, I just want to clear that up. Any questions?
Larry Phillips from Red Rapids Place. Is there anything in the fees area that prohibits from charging money for an internal move with different unit?
From a landlord charging for an internal move?
Yes.
Well, normally if the tenant wants to move and they have the means to do it themselves, the landlord can't insist on them hiring someone through the
No, sir.
landlord.
I meant if you have to end up with a month or two lost revenue, that you have to, and instead of getting somebody from the outside to come in right away, you got to fix that unit up, move the person out, and fix up the area for somebody else to move in.
So you mean like the tenant's abandoned or they've actually moved to another unit?
It's a relocation fee.
Oh,
From
okay.
one unit to another.
Yeah, again, like if the tenant requested relocation within the building. Normally they should have the option to do it themselves at their own cost and time, but if they can't do it in time and fashion, then they ask the landlord.
The question is, are we allowed to charge a fee for that? So one example is the building would take a rent loss, and need to renovate the suite. So is it legal to charge, let's say, 2 months rent, equivalent rent for the suite that you're leaving to cover costs?
That would be
something that you know, that's a policy that the building has. A tenant, yes, you can move to a different suite, but it's gonna cost you 2 months rent, 4 months rent, you know, the relocation fee.
I think if the tenant wants to move to another suite and they want to be able to move out without the 3 months notice that they're required to give. Because normally how it works is if I move out, like right out of the building.
That could be possible, but let's say if you have an 8-year waiting list, that's not gonna work for that person. So they bypass that waiting list. So they're not leaving and then reapplying.
No, I'm just saying that technically the most they're obligated to give notice for, even if it's just moving to another unit, the bill is 3 months. Of life lease. So
Okay, so,
if they move out before the 3 months notice,
no, okay, so there's a
Then-
house rules where if you want to relocate from one unit to another, there is a fee of whatever that the landlord can say. If you want to move, it's gonna cost you because there's admin, there's all these things that needs to be done for you to move, rather than you're moving for nothing. It has to be a fee that we want to charge you if you want to relocate from one unit to another.
Maryland
It's
said 10.
it's like the assignment fee, it's administration.
Well, they've been paid $75. In terms of additional fees, would really depend, like I say, if I give 3 months notice and you're letting me move with that notice somewhere else, but then I've left the unit a mess. Then I would, and I had to clean it as a landlord, I could file a claim for that, but I don't think you can have just a standard X $100 move to one unit to another, just for any fees you may incur. So you have to have actually incurred the cost as a landlord.
So the idea would be that you would actually relinquish the suite you're living in. Give your landlord 3 months notice. Purchase the suite you want to live in. So it becomes sort of an internal transaction, changing leases for going to the next. Get your money back, put your money back in. Does that make sense?
It does, I'm just trying to tie it in with what normally happens when a tenant moves out. So, or moves to another unit. So if I as a tenant say, I want to move to that unit across the hallway, will you let me do that? And I say, okay, yeah. And the tenant says, I want to move in there for a month. I would say to the tenant, well, technically, you're obligated to give me 3 months notice. If I can't find someone, even doing my due diligence to move in there, you could be on the hooks for the other 2 months for rent.
That's right.
But I have to have done my due diligence first. I can't just simply charge it. If you leave it a mess and I gotta hire someone to clean it. If you make it available, Lease Act, I'm gonna charge you for that.
Housing in Winnipeg?
Damage anything, I'm gonna charge you for that as well. I can understand. That if you don't give the full 3 months notice and I let you move to another unit anyway, and I can't find someone to rent. Go for maybe 2 months, whatever. I'm gonna hand you a bill for that lost rent.
So let me ask a question that's slightly different because we're not talking about complications. We're not talking about complications of neglect or whatever. A suite comes vacant. I want that suite for an internal move, right? Suite is already becoming vacant. And so we have 700 people on our waiting list. But the position is, well, I'm liable for 3 months of rent. And perhaps pay double rent because I would like to move into a newly vacant suite. And my suite is available to be rented out. Why should I have a 3-month threat of double payments?
Well, it's just, as a tenant, even if I'm moving to another unit building, my obligation for a life lease is to give 3 months notice to terminate my current unit's tenancy. And if landlord's okay, that's fine. But you have to understand, if I can't get somebody in there for those 2 more months, if I let you move to another unit, and I can't get someone else in there, you could be on the hook for that money.
Understood, but there's a vacant suite, so you already have somebody that's ready to take the vacant suite. It's an exchange of.
Yeah, if you have
vacancies.
someone who's gonna move in the next day after you've left, then the landlord hasn't incurred a loss. You have to, as a landlord, even tenant too, you have to have suffered a loss. It can't just be a fee for our inconvenience to move you, or it's just a standard house rule we have. There has to have been a loss.
Can we take some questions from the online folks? All right. Okay, so the first question, someone says, can you provide a link to the residential investment regulation?
Yeah, I can do that.
All right, so I guess you put it on the chat. And the second question says, do each tenant require their own copy of financial statements? Or is it a binder available for tenants? Or is a binder available for tenants sufficient?
I didn't quite hear that.
All right, so it's, do each tenant require their own copy of financial statements? Or is a binder available for tenants sufficient?
They should be, as part of their notification of the annual meeting, getting what I referred to, those 3 schedules or a version thereof. Like the summary of the refund fund, the reserve fund, and proposed budget for the following fiscal year. They should get actual copies of that.
But what about the financial statements? Like the audited financial statements, should each tenant get a copy? Or is it sufficient to just put a copy in a binder that's placed in the building?
Just double check here.
I'm reading is if the tenants request a copy, then they have to provide a copy.
Why wouldn't you?
Well, I have had that an issue in the past where they provided it at the office that's in the building. Anybody could just make an appointment and go. But tenants wanted the actual copy for themselves. You know, just want to double check there.
Geared a lot more towards profit or profit. Yeah,
I'll look for that in a minute.
Thank you.
a lot of bottom line talking here.
I still have a follow-up on this internal move thing. The landlord is out at least a month's rent as soon as there's an internal move. Instead of having one move and a month's vacant suite, there's another month. So the landlord loses right away. So I guess the question is, can they always charge 6 weeks or 1 month's rent, 2 months rent, just because you have an internal move?
Yeah, well, looking at it from if the tenant disputed that charge and you had to allow them to take the next step of file a claim for a branch. When I was a hearing officer, I can't speak to what happens at a hearing, because every case is different, but it was usually a no-brainer to give the tenant or give the landlord the first month if a tenant abandoned or didn't give proper notice. Because it's almost impossible to find someone who can move in. You gotta do reference checks, they have to get notice where they're at usually, so. Anything more than a month, then a landlord would have to prove to me that they did their due diligence. They were likely to be like you've reached out to those people on the waiting list to try to find the next person available. Really, all you have to show is like we did our due diligence, but we still couldn't rent it out for the remaining 2 months.
It's still, it's kind of impractical because internal moves say, I'd like to move to this type of suite. So as soon as one's available, do they have to give it 3 months notice then? Then the landlord has to let that sit vacant for 3 months. So the move.
I think what I think practical.
Deal with that in the house, you don't.
Says I would like to.
Policy about that.
Suite, for whatever reason, and the landlord's okay with that. Say, okay, you can do that with 3 months notice. And that will give me time to get my stuff together to find someone else to replace it, or just understand. We'd let you move now. Technically, you're obligated to get 3 months notice, do our best to find something. That time, but if we can, we will be giving you the bill.
Okay. Still not making my point, but I'll give up.
I think what you're doing is you're just exchanging one vacant suite with another. In either case, there is a vacancy.
But it's
If
an extra
the
month.
individual wants to move into is vacant, that's a vacancy. When the person moves out of the suite they're living in, the new one, if they want to change, there is a vacancy. So it's just a swap of which suite is vacant.
Well, not necessarily. The landlord usually there's some work to be done in that suite or stuff when the item's out. So you're looking at the first month, fine, it's the landlord's responsibility. But if it takes 3 months to rent it, 2 months should go back to the original owner.
Hey,
Yeah, I'm just looking at it as in typical case of tenant moves without no proper notice.
Right.
What can allow them? They lose rent, they can charge the board. If it gets disputed by that tenant, they'll have to show it will be good and be rented right away, but it's a couple months, we got to repair, we got to advertise, or whatever. It's gotta be sufferable.
That's the question. Totally different, totally different. Said there that the deposit has to be returned when you're leaving. But if you request deductions, could be made from it? Did I understand?
You can as a tenant,
So if I were going to leave and I have to go into assisted living, I'm going to assisted living where I have to pay. But I ask for my rent to be out of that so that I'm not paying for the assisted and the 3 months rent in my life lease. But I ask them to take the rent out of my deposit.
yeah, well, like I say, a tenant can willingly ask that a certain portion of their entrance fee be applied to any outstanding costs after they're gone. It's just that without an order from us, the landlord can't impose that.
Okay.
You talked about the need for a reserve fund study. The need for a reserve fund study. So that's something new. And how often does it have to be done?
The regulations, once they're finalized, will say how long, and more than likely, most of the changes, I will say that we're looking at making to our regulations likely somewhat near the condo regulations. That's, we'll see. So that's what I always look at, okay, if it's a reserve fund study or reserve fund minimum or whatever. What do they do with condos?
5 and 10 year.
Is that? Okay.
But that hasn't been, there's drafts, but it hasn't been decided, but the regulations will clearly state how often you have to have it.
Right.
Sorry? One of the slides mentioned audit, the majority of residents requesting audit. Does that apply also to forensic audit? Or just that current year's audit? There's a huge difference between requesting an audit for the current year and a forensic audit. What's your thoughts?
I think as long as the landlord is able to, under the new regulations, show they've used GAAP. I don't think we branch say this type of audit, this type of audit is not acceptable. We just look at what the standard measurements.
Yeah, but the gap requirement is current, right? A forensic audit would go back to something that to uncover something improper.
Yeah, I think currently it's
Thank you.
looking at the current picture.
Good.
A couple of comments. The Condo Act is the reserve fund studies required 3 years after the law was enacted and then every 5 years thereafter, just to clarify that one. And I agree with the consistency. When you were talking about the reserve fund study, my first thought was this is with the Condo Act. So yeah. And an audited financial statement, the first thing on any audited financial statement is the auditor's opinion. And the opinion, to get an unqualified, will say these financial statements present fairly your operations in accordance with Canadian accounting standards for not-for-profit organizations. So that's the same as what used to be called GAAP. So when you get an audit done, if it doesn't comply with those standards, the auditor is required to put that in their opinion. So you'll know right off the hop if they comply or not. That's not my question. My question is, oh yeah, I'm hanging on to this. I got a list. One of the things with some of the life leases are experiencing vacancy issues. And one of the things that we're looking at is renting those units at full market rent, but not to people who sign a life lease agreement, but just a regular rental agreement. But can we do that? And is there any kind of a percentage or threshold, because we don't want to lose our life lease designation. But is that allowable and how much of that is allowable?
So the act allows what we refer to as temporary tenants for life leases, trying to find life lease tenant. But you don't want to leave rent. You can put someone in there. And the understanding that when that temporary tenancy expires, that then they grow. Or certain are notices. Like, during that time, there is no minimum, maximum number of units. And fill in that way, just on the 2 days. But while they're non-life lease units, their rents will be regulated by the guidelines. So that's where it gets a little ugly, because I've seen buildings where they have half and half. You've got half the tenants regulated by the guidelines, share. Landlords can, however, if they feel both tenants, of course, you know, the budget is being covered by, let's say, guidelines. They can apply for both guidelines for a branch just for those units. And the other units, the regular portion share. I've seen that happen. There's no limit.
Okay. I think so. The only thing that scares me, and it just triggered into when you said temporary tenant, is we would still want to lease some kind of an agreement, let's say 3 or 6 months or even a year. Because if you look at it, and the words that are hitting me are short-term rental, and then the underused housing tax and the federal consequences of that.
Yeah,
Okay, I'm
you
allowed
can
more
do-
than that.
a temporary tenancy could be for a fixed term.
Yeah.
The reason why temporary tenancies are limited to 2 types of situations: if I own my house, I'm going out of the country for 6 months, and I want someone to take care of it, bring money on that, I'll rent it out on a 6-month basis, and then it's time I come back, I'm moving back.
Yeah.
Same with life. We're having a hard time finding anybody to do that. Come in for 6 months, and you gotta realize you're out. Those are the only situations where the act allows temporary tenants, for obvious reasons. If I was a landlord, every tenancy I have would be temporary. Because I could always get rid of a bad tenant. And whereas currently, I have to have a reason to get rid of you. Dispute my reason to get rid of you, and of course, we go to the branch, do a court of possession hearing, and all that. Commission process or appeal process. Yeah. Stretched out long process. That's why the temporary tenancies are limited to those 2. But it can be for a fixed.
Okay, thank you. I have more, but I gotta share.
Can we take some from the
Oh.
audience? Yeah, so I have a few questions here. It says, do the same rules regarding repair and maintenance apply for pre and post 1999 like this?
Yes.
Right. Second question here is, do you have any idea how often the reserve study? I think I have an answer. How often a reserve study will be done? All right, okay. Can we receive the slide notes by email? Is it shareable?
I would like to see.
Yeah, I can see about that. Usually you gotta jump through the government to get media specialists. Okay, and I've never done that.
All right.
But the one thing I do offer, I'm the main contact for anybody who has questions. Like, and always, you call me. I can send you whatever section, whatever act you want. Looking for decisions that may pass in regards to certain items.
Okay, one more. It says need for trustee. If the co-op life lease is pre-1999, are there many other co-ops wanting to get out of trustee relationships with Concentra? Says need for trustees. If co-op life lease is pre-1999, are many other co-ops wanting to get out of trustee relationships with Concentra?
So we were just talking about that. If it's pre-1999, certain sections of the Life Lease Act. And one of them is certain components requirements for the trustee. However, if you as even a pre-1999 have a trust in place, you have to always continue to have that trust and replace them if they retire at the time. But if you've never had a trustee as a pre-1999, currently the way the Life Lease Act is written, you're not required. For that now.
Right, that's all I have on my, so.
If I could just try to clarify, the area where you said that when there's an assignment, that the maximum that can be charged by the landlord is $75. Does that mean like in a situation where the property is in the name of both the husband and wife, the life lease is in the name of both the husband and wife, but then the husband dies? So then the wife now has to get the land titles, like in our case for our building, because we are on land titles as the owner, we have to go through a lawyer, have all the documents changed again to put it in just the wife's name. But our landlord charges $750 to redo our assignment then, to redo the lease agreement.
Well, all I can say is based on the way the act's written, right or wrong, it limits it to 7,500. I've heard lots of comments, yes.
So,
But that's just the way the act is written, so. Now, in this case, you're not moving out.
no.
So they're taking on the responsibility of doing that to the place.
Well, I have to pay a lawyer to get the land titles changed,
So
but they have to do some signing as well. The landlord, like the land titles has both the landlord's name on it and my name. That's the way ours is structured.
The way I would look at that technically is current tenancy with two tenants being terminated and being renewed with just the one tenant, which we, the first, the act treat as a new tenant. You're the same tenant, but you treat it as a current new tenant.
Right.
So that tenancy ending, the maximum amount of charge sign. So.
Okay, then we'll have to maybe get into discussion on that. Thank you.
Just leave it the way it is, and provide that should.
I just want to clarify one more thing, Darren. You said that at the beginning, that life leases were affordable. It was life leases considered affordable rent. Am I just saying that you're saying that that's what they are, they're affordable? They're not affordable housing, or affordable rentals are, manageable housing or geared to income, that type of thing. Life leases are not affordable housing, they're, I guess, going to be below market value for rental. Is that more of a correct assumption?
Thought process with life leases were first came into play was to provide affordable housing to seniors who sell their house and receive for the development of the site lease complex and then pay a reasonable rent. But you're right. In this day and time, if you're not subsidized by Manitoba housing or geared to income in some way, any kind of rent units are fairly significant rent. Life leases do tend to be below market, but still the rents are going up. Part of the problem is that I hear from board members, property managers, tenant reps, that the entrance fee or sorry, the reserve fund has been collected over the years. And tenants have technically benefited from that by having limited rent increases or not overly significant. Now you have all these issues with the building, reserve fund needs to be built up. So all of a sudden, rent increase for $100 a month, $100, $30, $40. Yeah, the only recourse they can have a non-problem status.
Gentlemen, the sound is terrible. You know, you're breaking up, can't hear nothing.
One thing that you look at are reserve funds study. Big part of the rent increase is contributing a significant amount of the reserve fund. Talk about the point that needs to be in reserve fund study is very necessary. Probably not dispute that part of that increase, and that's why we made reserve fund studies necessary, so we have the documentation to make sure that part of the increase in rent is justified by official study that went
Okay, sorry. Yes, I didn't have hands up for a while, so. Yeah, Irene, we could take your question.
Okay, I'm Mound Estates Housing Cooperative in Pilot Mound.
you
I have a
unmute?
question regarding, I have a question regarding trusteeships and the costs for places like Concentra. Are there rules and regulations about the costs that commercial trustees can charge cooperatives? And second question, for those of us who are pre-1999 cooperatives, I understand that we no longer have to have a trustee that is a commercial trustee like Concentra. And what assistance would we have or in getting out of our agreements with them, which are extremely costly? It was $5,000 to get in and over $1,000 a year for us with 16 units. And I understand $5,000 to get out.
Irene, can you repeat the first question? I didn't catch part of that.
Did you want me to repeat?
Yeah, the first question.
Okay, first question, we are required to have commercial trustees like Concentra. Wouldn't you know what? I'm sorry, I'm on the phone now. I got to get off. We are required to have a commercial trustee like Concentra. The costs of Concentra are extremely high. Are there any rules or regulations about commercial trustees for life lease properties? And the second question is, many of us are pre-1999. I understand we no longer need a commercial trustee who is an external trustee for our properties. Some of the other organizations are having difficulty in getting out of their agreements. How would you suggest that we do so?
I think as long as the landlord, in terms of trustee they have currently, or they're going to renew it, is doing so in accordance with Life Lease Act and Life Lease regulation. We wouldn't really get involved outside of that. We would advise the landlord what they're doing wrong and what they're doing right. The only issue we have with Life Lease Act right now is unlike the Residential Tenants Act, the landlord doesn't live up to an obligation. So let's say they ignore the regulation and things to a trustee, and that's whatever. And the tenant notifies us, tell the landlord, okay, what you're doing is wrong, this is what you have to do. And they just ignore us. Currently, there's no admin penalties or something like that, fines in place, so we can close on like lease landlords. There are certain situations that other types of landlords can do that. Currently, the way the Lease Act sits, we can only advise. So what I would recommend is, if the board has specific questions about current trustee or a renewal they're looking to do, just send me the information, because I won't lie when it comes to trustees and investments. I have to sit down with the legislation on one hand and have the whatever agreement or proposal on the other hand. It's not something I can't retain the entire, like Lisa asked, so things like that. If you can get me that information, I can definitely take a closer look at it.
I just had a couple questions on the reserve fund.
You might come in a little closer.
So just in regards to, is there any further, I guess, guidelines with the reserve fund? Because right now, technically, as per the act, we could have $1 in there and we're compliant.
Yep.
And so I guess future-wise, because reserve fund studies are pretty broad, and they will, in our view, kind of, I would say in one sense, go way over above what the, let's say maybe what the real costs are. So they might value a reserve fund at $2, $3, $4 million, depending on the size of your complex. So will there be any further guidelines within that will say, let's say if there's a reserve fund study that says you need $1 million, there would be a minimum that would say, yeah, you need to have at least 10% of what the reserve fund is saying?
That's one of the recommendations that's been made, to have some sort of minimum built in place, whether it be a percentage of what the reserve fund study. Another thought was, most reserve fund studies have like 4 tiers of recommendations, and what do you do? Take the one in the middle, you know, or is it just a percentage of the amount of what the full refund fund will be if everybody's entrance fees covered? Is there a minimum percentage, like 1/3 of the tenants or something like that? So there's been a few different ideas, which I'm working on. That's one of many, but it has been a bone of contention that there's no limit, or no minimum, I should say.
The reserve fund, now, as I understand it, this is now being mandated by government, but certainly that's got to be the low standard, right? It's the safety net, as opposed to what I would describe as good management practice, which really ought to reside with the board as to how they would treat an aging infrastructure, and a reserve fund sets a minimum, but that doesn't make it good practice. It just makes it the law of the land and a minimum. Am I correct in that, or do you see it different?
Well, a lot of the amendments have been proposed that we're looking at are to make landlords more accountable when it comes to their investments, their reserve funds, their refund funds, their trustee requirements and all that sort of thing. So, yeah, it's up to us, in my opinion, to make sure whatever standards we set through the act and regulations, it's for the good of the building and tenant. Right now, well, as most people know, there's not a lot of minimums, not a lot of requirements, not a lot of restrictions. I mean, it's just, the first step, I guess, was the reserve fund study requirement. Next step will be, what do you do with that?
I'm gonna jump over to, there was a slide that talked about if you have a deficit in your operations for the year, you could more or less invoice each of the tenants for their share of that. And if there's a surplus, it must go into the reserve fund. And I think it said it must go into the reserve fund.
is there the option of keeping it in the operating fund that you might want to reduce deficits from prior years being carried forward where you didn't bill the tenants, or hang on to it so that you could keep the increases in future years down a bit, because you can take that surplus going forward and use it for future expenses? Is there that option? Because I think the slide said must go into the reserve fund, but I'd like to know if we have a couple options when we have surpluses.
Yeah, it boils down to the life lease agreement. So if the life lease agreement says that, this is what we're gonna do with the surplus. And maybe there's different amounts you put somewhere, operating reserve or refund tenants.
So do agreements override the legislation?
The legislation, again, that slide probably was misleading, doesn't really talk about when there's been a surplus or a deficit.
Yeah.
That comes down to the life lease agreement. And if there is one where it's sketched, currently tenants have to be refunded with a surplus, but then the board decides, it's better if we put it towards operating expenses, deficits of some sort. You would have to get the tenants to agree to it.
Yeah.
So that's a change in the terms of the tenancy agreement, but if everyone agrees with it, it's fine. We just have to amend the life lease agreement as it is, go forward from there.
Okay.
I have a question online. It says, as the manager of my life lease building and also a certified reserve planner, will I be able to perform a study or will it be a conflict of interest?
I didn't catch that one at all. I'm sorry.
Says, as the manager of my life lease building and also a certified reserve planner, will I be able to perform a study or will it be a conflict of interest? Yeah.
Manager of the building.
Manager of the building is also a certified reserve planner. So it says, can he do that or will it be a conflict of interest?
Manager of the building is also what, sir?
It's also a certified reserve planner.
Oh.
Yeah.
The manager is the one conducting the reserve fund study.
So he's asking if it's going to be conflict of interest.
I would have to take a look at. I just want to take a quick peek at.
If I can suggest something to that, if there's no requirement in the legislation to be independent, then I would say there's no conflict of interest. But sort of as a CYA gesture, I would openly disclose that and have the board pass a motion to appoint him, but also to make sure that the price is fair. Just get quotes from other companies. That's my thoughts. Oh, yeah.
I think that in the condo act, the reserve fund studies have to be done by the qualified.
Yeah, and our proposed regulations for life leases would be similar.
Yeah, and then they have the qualifications set out.
Yeah, the qualification, who can do them, what kind of certificate you have to have and whatnot. If he meets all of those qualifications and just so happens to work for the landlord doing something else as well, I don't really think there'd be a conflict.
Okay, so is there a fixed maximum time with which a refund must be paid out if a tenant leaves?
So again, that's your post versus pre-1999, right? So there is a time limit that a tenant has to be repaid for a post-99 lease. If it's pre, it depends on what the life lease agreement says.
The entry fees. I know they're probably different from different buildings, circumstances. This was originally to help offset construction costs. And I know that in our situation, you can add money to your entry fee, and that additional fund have so much per year or for whatever period they set will offset your rent again.
Yeah, that's a common thing landlords are looking for when they need to build a reserve and don't want to jack up the rents. Is to increase entrance fees higher than the norm for new tenants.
Yes, but I mean, existing tenants.
Existing tenants.
Would add money to their, entry fee. They top it up and top it up and top it up, until you get a couple $100 off rent.
Yes, it's normally called the second security fund.
That's, yeah.
Again, that one boils down to what the life lease agreement says. Life Lease Act doesn't really address that. It's just considered another type of entrance.
I just have a very general question. How many life leases exist presently in the province of Manitoba?
How many we got on you guys have on your website for the MLL? My memory.
We have about 30 and 40 registered active members in the License Association. But we've identified up to 100 throughout the province and are actively looking for them. So it's very difficult to find them. The registration in the Corporations Act doesn't designate life leases. You have to be searching through all the files. It's a laborious process, but I'm doing our best.
How many of those are
We've done about 100. But members of the Life Lease Association and the Life Lease Occupants Association, members about 40.
how many not?
Most of them, I'd say 95% of them are nonprofit.
Question, Darren, you're the guy who eats and breathes this stuff and you're kind of the guy in the know. I'm gonna dovetail on the other gentleman's query about the second security fund and the reduction in rent that the tenants get when they contribute. CRA's been hovering over that for years about is it income? Is it investment income? Should they be taxed on it? And I've also recently been hearing rumors that CRA may start part of the tenancies, I guess, legislation they want to bring in federally, that they want to say that you can't contribute to a second security fund anymore. And they're trying to get involved in that. Now, right now, we're provincially legislated. I'm assuming if federal legislation comes in, it's going to override. But what have you heard through the grapevine about these? Is this likely going to happen? Is it a pipe dream for some politician who wanted job security and made it up? Or I'm speculating, but I want to know what you've heard. You're the guy that's in the know on this right now in the province.
CRA, from what I can tell, have tiptoed around this subject for decades. Because technically, by definition, you are investing money and getting interest that is tax-free because it's in the form of a rent reduction. I honestly have not heard anything provincial-wise of them coming down on us to change things, or that would be totally their jurisdiction, to be honest with you. And if they said, no longer can you do this, or if you keep doing it, you're gonna have to pay interest, we would have to abide by their change in legislation, I guess. But personally, I haven't heard anything. I know it's always been sort of a, I don't know what to call it, it was just sort of something everybody was aware of, but nobody was doing anything about it.
Yeah.
So,
Yeah.
but I honestly haven't heard anything.
Okay.
With the CRA, we're also paying the rent that we declare is also at a reduced rate. So to the CRA, we're really not doing anything more. Because we're declaring a less amount per month than a regular somebody that doesn't invest in the past.
And that may have been, again, I don't know, but that may have been their sort of justification not to get involved with this any further. I really don't know.
Concentro is handling some of the CRA business. They want the forms filled out. Now, this was generally ignored because most of the tenants felt that
the CRA didn't need any more, knowledge of their estate planning.
I'm with you on that
I
one.
think Documents Association got quite involved in that little debate. And the issue that we had, and the conversations we were having with our members was that Concentra, or these trust companies, only Concentra, were asking you to give them your social insurance number and your date of birth.
Oh.
And our issue, of course, was you should never, ever, ever share your social insurance number and your date of birth with a third party, anyone other than the lieutenant. And Twitter, but certainly not with, so I don't know quite how that issue got resolved, but that was our recommendation for it. Like an explanation.
Question? Yep. Or says sorry. Says can budget overages be used to pay down the loan? If so, do the tenant have to agree if the board wishes to apply those funds to a loan?
Sorry, it must be my hearing. I'm having a hard time hearing you from there.
All right. Says can budget overages be used to pay down the loan? If so, do the tenants have to agree if the board wishes to apply those funds to a loan?
So they
Surplus, can they pay down a loan with the surplus?
If they have a budget overage or surplus, can they pay down?
Oh, to pay down the mortgage.
Yeah.
Oh,
And it says, do the tenants have to agree if the board wishes to apply that to the loan?
if it's not currently in the life lease agreement, and the board wants to have that flexibility, then they'd have to get all the tenants to agree, and they'd have to modify their life lease agreement.
I also like a quick comment about this affordable housing designation here. I know that on the original, article of incorporation for the building that I live in, that was first and foremost in the document, that the purpose of the building was to provide affordable housing for. That was 25 years ago, those were 30, when those documents were drafted. And the term affordable housing had a very different connotation during this ago than it does now. So I think that's where people get confused about attaching that moniker to life lease residences. Because affordable housing now means not affordable housing, now means low rent housing, now means subsidized housing, which is not right, life lease residences. I think possibly a more appropriate term would be accessible housing. And that people can choose to move into a home that they can call their home with a relatively small amount of capital investment in that. So I think accessible is better. Affordable. Yeah. I think that.
I had a list of questions sent to me prior to this meeting. I think I've answered most, but, a couple here, while we're talking about subsidized housing, one question was, is there any way that people who are in life leases can get rent subsidy? I have seen that. I've seen where a life lease complex has had what we call a forgivable loan. And what that is Manitoba Housing provides you with a loan. And every year as the owner, the landlord, you keep the rents to a certain level, which are supposed to be affordable. And how Manitoba Housing, I don't want to speak for them, but from my experience, they determine affordable housing is they look at CMHC statistics for that area to see what the average rent is, and then they reduce it by a certain percentage, and that becomes an affordable rent. And part of the forgivable loan is every year, as long as the owner keeps it at that level, Manitoba Housing forgives a
portion of that loan, and every year thereafter. I have seen subsidy geared to income as well. So that's something you may, as a board member, want to contact Manitoba Housing about, see what options are available. But I have seen it in the past. I had a question, how often can the rent be raised and by what percentage? So even though non-for-profit are not regulated by the guideline, they are regulated by the Act in 2 ways. You can only increase the rent once every 12 months. And you have to be given 3 months written notice before that. There's a matter where the Lease Act and Manitoba Corporations Act contradict each other. Which act has the overriding authority? In our Lease Act, near the beginning, it says if there is a conflict between this act and any other act, this act prevails. I've answered all the rest, I guess. The other ones were, can you have some non-life lease units temporarily? What the regulations will touch on in terms of refund study requirements. I think I've answered, but if the 3 people that sent in, there was Margaret, Scott, Ramona, and Fran. And that, I guess. Is there any questions I haven't answered that you sent in?
No, but I have more.
No more questions.
Oh, I'm sorry. The whole reason I come to these is to get my questions answered. We have board meetings or we have tenant meetings or information meetings and questions come up and I go, I don't know. So Darren's our expert. So another one I had is you commented that it's often difficult to have a residence information meeting 6 months after the year end because the audit's not done or information's not available. And then you had commented to someone else about when the notice goes out 30 days, it should include the audited financial statements, the schedule K, the schedule. Sometimes, is it just the notice that has to go out 30 days or are we obligated to include the financial statements in that? Because sometimes they may not be available until the day of the meeting or a week before the meeting, and then we distribute them at that time. Or if they're not ready and we have to have a meeting within 6 months, can we present internally prepared financial statements or unaudited and just say the audit's coming, but with a warning that they may change because there's always adjustments from the auditor. So I'm not sure what the best way is to handle that with the tenants that want the correct financial information, and they should get the correct financial information, but the timing of the 6 months. How much trouble do we get in if we don't do it within 6 months? There's my question.
So under the act, it does say that the content of the notice will include those statements. Right now, is there any sort of penalty from us? No.
Okay.
Sometimes it's just a matter of reminding the landlord, but most of the time it's sort of like the board's like, well, he's just not providing them yet. We're waiting for them. So it's kind of tricky that way, but.
It gets very tricky if the audited financial statements show a loss and the tenants are required and requested to pay an additional fee. So it's quite important that every effort be made to adhere to this maximum 6-month rule. And 6 months from anybody's fiscal year end, if you're keeping the books clean, is plenty of time to do an audit.
Yeah, I haven't really gotten any sort of consistent explanation why 6 months didn't do the trick. Or it's always they blame it on the account. So, 18 months.
Yes, auditors are in charge.
I could get rid of that account.
Auditors.
Yeah, like I said, one of the recommendations for possible legislative changes is to put in a min penalty for life leases where they're not abiding by some of these certain obligations, one of them including giving financial reports. Cause that's one of the biggest obligations landlords have on their life lease agreements. Be upfront before the tenant moves in and be upfront year after year about budget, the expenses, the benefits, the losses, whatever. it is.
The issue of applying penalties against landlords, for non-compliance with the legislation, of course, is that these costs tend to get passed down to the residents. So,
Yeah, in all of the events,
I
yeah.
don't know if any,
yeah, I'm reading here, so there has to be some other mechanism for landlords and possibly management companies to assume some financial and ethical responsibility for these kinds of things that is not passed down to the tenants.
I don't know if any of you have read section of the act, but it's on the current penalties that are in place. If a tenant wants to initiate it. And it's basically, you'd have to get your own lawyer, go to court, and then it could result in prison sentences and major fines. But at the end of the day, no one's really looking for that, and who pays for it? Because you not only would pay for it as a tenant, if you got a lawyer, the landlord may try to pass that off on you when renting.
Exactly. That's what I'm saying. That's exactly the reason, yes.
Wait a minute, who goes to jail? The board members?
You know what?
Because my resignation's gonna be on
Get excited.
about 30 seconds.
Excited. I think it just let me just check, but it refers to landlord, I think. Let me just double check.
Okay, we gotta talk.
Can I have a question?
It's never been done in the 20 years I've been doing this, so.
That's okay.
Yeah.
Yeah.
So it's a
Uh,
section of the act, if anybody, it's 30, starts at 38-1. And, every director, officer, or agent of a corporation is guilty of an offense. Could be guilty of an offense.
And that could be the property management company then too, if you've got.
I would think so, yeah. But yeah,
I
like
have
here
a
you've
question.
got $50,000 fine. I think it's up to a certain number of years in prison.
Seems easy to do.
Hi, maybe this is a question for other life lease buildings. The allocation of the common costs, like normally our monthly fees are based on the allocate percentage of your own square footage of your unit. And then that gets the operations surplus or deficit, then you get your share of the percentage, okay? If are the other buildings allocating the percentage strictly based on the unit cost or unit square footage, or in our situation, I believe that that's the way it is allocated, just the square footage of your unit. But there's differences between the units in the fact that some of the units have ownership of underground parking. Some have outdoor parking ownership, and some have zero parking.
So
Neither.
We normally separate the parking from the base rent, what we call it. Yeah, and answer your question, are most
Like, they
places-
don't pay rent for the parking spaces.
Parking is considered.
They
part of-
buy, when they buy the unit, they buy the parking spot as well.
So they're probably paying a monthly amount that's built into their total rent, which is okay, but.
For the
way-
parking, you mean?
Yeah, the way the act's written is that you've got your base rent, which in terms of non-for-profit is usually a proportionate share based on square footage. Then you have other fixed charges, and that can include cable vision, parking, storage lockers,
Okay,
which may or may not be optional. Some landlords don't separate them out. But again, it comes down to the life lease agreement as well, because there's different ways to calculate proportionate shares. I'm working on one now where for the majority of the operating expenses, they take the unit proportionate share based on square footage, but they take the taxes and the mortgage payments out. And they calculate that proportionate share as you get if there's 40 units, each tenant pays 1 out of 40 of that part of it. So there's 2 components. But as long as there's a clear in the life lease agreement and it's a proportionate share of some sort, then you're acting as a non-for-profit in accordance with the act. I have had a couple where I've had to recalculate all the rents because I had no clue what they were doing based on what the life lease agreement said. Some of them have little disclaimers that the board can make little adjustments where they see needed. So when I'm doing a review, you have to be able to explain to me what you did and why. If you can't, I'm gonna stick strictly with the life lease agreement. But when I decide what the base rent can be, I don't really include the parking. That's always a separate charge. Like I said, landlord may include in that tenant's total rent. But I just look at the budget and what, I look at the budget, what are some of the revenues you're gonna earn? And then what's left that the base rent has to be, and how is that calculated for each tenant? As per the life lease agreement.
I guess it's something I would need to go back to my management to ask them how our percentages are calculated then, and whether or not there is a differentiation between whether or not you have no parking or indoor parking.
Yeah, like they may make some sort of adjustment on the backside.
Yeah,
I can be honest, I've never had a life lease review that was not complicated as heck, because
yeah.
like,
Yeah.
when they come in, I just sort of bang my head against the because their life lease agreements are so convoluted and confusing, and a lot of times the boards have made some sort of adjustments that I can't figure out, and they can't figure out. Wow, we just always done it that way. That's not good enough. I need to know why. So,
Yeah, it isn't specified within the agreement. It just tells us our agreement tells us what our percentage is.
yeah, and sometimes for me, when I do a review, I gotta go all the way back to the
Yeah.
beginning and figure out, have you guys gone astray somewhere? And I can't go back, but I can fix it moving forward.
Thank you.
Our life lease seems to be a little bit different than some others. We pay for our unit, like, you're not getting that trust built. And those charges are $250,000. Plus to get into the building. Unless it's. But then you're charged common area charges, and I'm just wondering if there's any regulation or suggestions as to how to charge those, what charges can be put under the common area charges. Our common area charges $900, but they're based on your square footage. But that also, it's done on a budget, but the budget has maintenance and all the administrative costs. And those seem to be things that can't be identified as far as whether they're realistic, because we are also part of a larger town. And so administration works on behalf of different. So it just, there's big questions that have arisen from how these common area charges are. Is there anything in the legislation?
Not really. I mean, when I do a review, I don't really get caught up in the semantics, what's called what. I'm more, is this specific to this building? Is this a reasonable expense given your track record of what you paid in the past? I have, detected in certain reviews where money was being budgeted for that had nothing to do with the building. Or had nothing to do with the building, or had something to do with the building, but it was a commercial space. Which I didn't allow, because that's not the tenant's problem, it's a whole separate issue. Those are the things I look at, not so much, is it considered an operating or a carrying cost or a capital cost or a admin cost? Just whether they're reasonable, specific to the building. But there's nothing on the act, like what is a common area cost by definition?
It's 12 minutes to 12, so we're doing pretty good time lapse.
Do you want me to put my email up there for you? Okay. We should put it, yeah, I did put it on the chat.
Right, I think that wraps it up then. Thank you, everybody. Thank you so much, Darren, for coming here and facing all of us and being so helpful with answering questions today. And thank you to Manfo as well for putting us together, and to the Life Lease Association as well. And you can email Darren as well, and Dorian and I, who are the facilitators, we will be sending the information by email to the people that register for the event.
So it has to be capital D.
Yes, it does not.
Does.
There's a few things I have.
I'm just gonna give you guys the link to.
I put it on. They don't. I just. Sounds right.